good morning again. It's really great to be here. What I will do in the next hour or so is to speak about some of the key principles of the UN Convention on the Rights of the Child, the convention that was adopted by the UN General Assembly in 1989, and that Indonesia has signed and ratified as well, which make it a relevant framework for the work that you guys are doing, those who work directly with respect to guidelines, safety guidelines for children, like the group number 2 that we just heard a fantastic presentation, but to all of you who work in the human rights space and directly or indirectly deal with families and children. So in the next hour or so, we'll speak about very briefly about the theoretical foundation of the convention, and then we'll do a deep dive into the 4 guiding principles of the convention. The slides are detailed, and I won't go into each and every slide. I won't spend too much time on each slide, but I wanted to create this resource for you so you can use later on. And I'm always happy to answer any question that you might have and to continue the conversation over email. And feel free to interrupt me and raise your hand or populate the chat function with some questions, and we can make it a live debate rather than you have to listen to me speaking for an hour. That's a very particular joy. So the UN Convention on the Rights of the Child didn't come out of the blue. It comes after a fairly long history in international human rights law that protect to various degrees the rights of children, and it's very much enshrined in Western ideas about liberal human rights and the centrality of the nuclear family in the life of a child. Other traditions that look at children and families and the ecosystem around the society and state in different ways, different comparing to the Western Northern European tradition, haven't informed the creation of international child rights law too much. And there is a shift or a move in the space of human rights in general and of child rights as well, in incorporating different approaches to human dignity and to human agency into this space. And it's an ongoing process where on the one hand we have this universal instrument of human rights. All nations on earth have ratified the Convention on the Rights of the Child beside the US. And in that sense, the convention represents, if you would like, universal law that should be applicable to every child anywhere in Indonesia, in any other country, save the US. But it inevitably requires some local modifications. So it will become relevant to children on the ground and those who advocate and work on their behalf. And one of the first thing that the convention does, and in Article 1, it's trying to tell us who is this child that the convention asks to protect its right. We more or less know what human rights law is, but when we speak about children, we should identify who this child is. If you don't come under the rubric or the definition that Article 1 provides, then you are out of jurisdiction for the purposes of this convention. If you are not a child, the Child Rights Convention is not applicable to you, and it doesn't create any duties and responsibilities for those who have duties for children, mainly the states and the child's parents. So Article 1 tells us a very particular story. It tells us that any human being who is below the age of 18 is considered to be a child for the purposes of this convention, creating a very clear cut of who is in and who is out, reflecting again a Northern Hemisphere definition of when a person reaches adulthood, when a person is no longer vulnerable, when a person does not need enhanced protection, when this person is considered to be an adult, a competent adult who is expected to look after himself or herself. Other societies might have different ideas as to when a person comes to age. And usually in more traditional societies, the age is lower and it's more closely to the age of puberty. And marriage laws are therefore enables humans or children, if you would like, that are younger than 18 to get married and thus forming their own families and assuming responsibilities for their own life, including the expectation that they will be economically independent and will raise their children. But the age of 18 is only, it tells us a very partial story. It's still, according to Article 1, we still don't know what's the lower age as to when a person becomes a child for the purposes of the convention, and that's intentionally. There was a huge debate when the convention was drafted, and it took 10 years to draft the convention between 1979 and 1989. And one of the main debates was whether, when life begins, essentially, and whether the convention should be applicable to humans after conception, during pregnancy, or only after we have a living birth, not least because it reflects some religious views about conception and pregnancy and sexual intercourse, but also it can create a potential clash between the rights of the unborn child and women. For example, in the context of abortion, if the unborn child has a right to life, and the convention, as we're going to see later, protects the right to life in Article 6, then abortion is a potential violation of this right. So the decision was not to incorporate any lower age into the convention and leave it to states' discretion to make decision that fits their local customs and tradition. But even with the upper definition of Article 18, we still see, and you know from your own experiences, that the age of majority is different, and that children, usually during their adolescence year, between 12 and 18, with respect to certain aspects of their life, are being treated as adults, as if they are competent and should bear responsibility for their action, as if we can trust them to make the right decision. All phrases which are often used as a justification to deprive children from their right and not to recognize their human dignity, saying that they are immature, irresponsible, lack of capabilities, and therefore they should be subject to paternalistic attitudes when adults tell them what they should do and when and how and why. But I'm sure that the situation in Indonesia is the same. The voting age, while it might be 18, is much higher than the age where one can get a driving license. And driving license is not something that should be treated easily. It's a reflection of a legal regulation or opportunity for children to assume responsibility, where the law enables them to sit behind the wheel and expect them to keep themselves safe, to keep their fellow passengers safe, not to kill anyone when they drive, pedestrians or other drivers. And if they do, they will be subject to the same, usually the same penalties as adults. But by and large, when a child can get a driving license, in some countries at the age of 15, in others 16 or 17, they are being treated like adults for this purpose of their life. Other ages where the child reaches maturity is when the child can work legally under the local labor laws, when compulsory education begins or ends, when a child can provide consent to medical treatment, or the age of marriage. For example, in the age of criminal responsibility, which is usually much lower than the age of 18. All of those instances represent a situation where there is an incoherent treatment of children under the law. While we box all humans under the age of 18 in one category, call them children, and then subject them to a range of regulatory frameworks that usually don't do a good enough job in protecting their rights and welfare and safety, the local laws as well recognize children as adults in some events in their life, and this can expand. This list can be expanded and changed, but nonetheless, it means that we can take a much more nuanced approach towards children. This is a very much Northern Hemisphere history of how child rights came about, again, based on either the will theory of rights or the autonomy theory of rights, comparing children to adults. suggesting that children are lacking in adult competencies and therefore they should be subject to protection. At the beginning of the 20th century, we see a departure from that, a brief departure from that idea in favor of recognizing children as individual rights holders, that their unique needs and rights ought to be recognized and protected. In Sweden in 1900, a book titled The Century of the Child was published by a primary school teacher, where she, Elena Jeb, suggested that children should be liberated from the oppression of their state, of their parents and of the state. And then throughout the 20th century, we saw a shift between this need to recognize child rights and to see children as individual child rights holders, which are separated from their parents and from their families, and a competing perspective, if you would like, where children were seen as vulnerable people who should be protected by society, by their inherent, either due to their inherent vulnerability or due to their inherent lack of capacity. There was a brief moment in the 1970s, mainly in the US and the UK, where was it a call to liberate children, to remove any differentiation between adults and children when it comes to human rights law, and to treat children equally, and to remove any legal barriers for children that prevents them from acting as adults, including the age, for example, minimum age for obtaining a driving license. And the suggestion was, if someone can sit behind the wheel and pass the driving test, it doesn't matter how old this person is. Age, in other words, is not a proxy for vulnerability or for capacity, and things should be done on individual basis. If you were waiting with your own driving license until you were an adult, you don't get it automatically. You don't just go to the registration office at the age of 25 saying, I'm 25 years old, give me a driving license. You need to sit down for the test. If a 10-year-old can pass the test, so there is no reason not to give him or her a driving license too. That, broadly speaking, that was the crux of the argument. As I said, it was a very brief moment in history, not least because it creates a lot of problems. It was rejected across the board. In international law, and a range of documents have tried to codify a range of rights for children, beginning in 1924, and we ended up with a convention in 1989, which is much more comprehensive. It's a long document. As I said, it took 10 years to draft it, and it includes around 40 different rights for children. In general human rights law, we have general conventions that in principle are applicable to children, but experience show that it was very rarely that children were seen as objects and subjects of rights under these conventions, and their human agency dignity haven't been promoted under this framework. And it's similar experience. It is a similar experience with the experience of other marginalized groups, and therefore from the 70s onward, we saw a gradual development of group-specific conventions, beginning with CEDAW in 1981, the Convention of Elimination of Discrimination Against Women, that was adopted out of the realization that women need particular attention, that their needs and personalities are different, and therefore a convention needs to address them. We have the Child Convention. In 2006, we saw the adoption of the CRPD, the Convention of the Rights of People with Disabilities. You're going to have a class about it next week, hopefully, with Rosemary Keynes, my colleague. Again, out of the realization that this particular cohort hasn't been served by international human rights law adequately thus far. On the regional level, we have different mechanisms that includes to different degrees references to children and to families, but none of this mechanism have direct application in your line of work in Indonesia. But when we think broadly and we try to learn from best practices elsewhere, it might be worth looking at what happens in these spaces too. They often, or I won't say often, they sometimes do a better job in protecting the rights and welfare of children comparing to what the utility and the implementation of the CRC do. that's, again, as a point of reference, this is how the first document looks like, very short, 5 documents, not too elaborated. And we ended up with a convention that protects these sorts of rights, recognizing civil and political rights of children, socioeconomic rights of children, and the list is in front of you, but also a set of unique rights for children, rights that we as adults don't have under international human rights law. For example, the right to an identity. Sorry, what happened? The right to an identity, which is crucial for group number 2 and the sort of work that they are doing. Recognizing that the child needs to have a name and nationality and to know and to be raised by his or her parents, and that removal of children from their parents' custody is an act require justification. Article 6.2 also is a unique right of children. It enshrines the right to survival and the right to development of children, which we're going to say a few words about it slightly later today. Another innovation is the right to play and leisure that we as adults don't have. The convention recognizes in Article 31 that children have the right to play and to leisure as part of a mechanism to support their overall development. And again, as a reflection of this European bias, with the assumption that children go to school in the morning and then come back home and spend the rest of the afternoon enjoying themselves. That's not the reality of many children, not the reality and the routine of many families, but nonetheless, that's the expectation that the convention creates for children and for family. And lastly, Article 12 of the convention, which is one of the main innovations of the convention, that recognizes children right to participate in decisions concerning their life. Try to end the practice where decisions about children, either as individuals or as collectives, are made without their involvement and even without their knowledge. It suggests that with respect to any decision concerning a child, the child has a right to form their views and to express it. We'll speak about that in slightly greater details in a second. But the idea is that children should no longer be passive subjects to any adult decision, and they should have a seat at the table, children of any age. And in 2005, the UN Committee on the Rights of the Child have defined these 4 articles as guiding principles of the convention: Article 2, Article 3, Article 6, and Article 12. Meaning that in every decision concerning a child, these 4 guiding principles should be upheld. And this is why also I began my feedback to group number 2 with mentioning these 4 guiding principles. They should be at front and center when we're developing policies and developing legislation when it comes to children. And they should be at the back of your mind as well when you think about child-related policies and action. And we're going to focus our attention today on these 4 guiding principles. And after the break, hopefully we'll say a few more words about child welfare and juvenile justice. But before we dive into these 4 articles, does anyone have any questions or comments?
Noam, there's a question in the chat from Vitria, which
okay, just looking. Yes, so I didn't see the chat as I was talking.
That's okay. So she asks, has there been any update of international children's rights in relation to impact of COVID-19 pandemic? Many children have lost one or both parents.
The answer is yes and no. Development in the sense of there are no new mechanisms that were put in place as a response to COVID-19. What we have is a statement. If you look at the positive development, we have a statement that the UN Committee on the Rights of the Child, the body which is responsible of monitoring the implementation of the convention, sorry. So they issued a statement in April 2020, shortly after the outbreak, calling nations to consider child rights in their public health measures. But I think by then no one realized what the scale of the pandemic would be and how it will affect children. at the beginning of the discussion, when schools around the globe were closed, so most of the discussion about COVID-19 and children was about school closure and how school closure will affect children and the social isolation and educational opportunities and the connection with their peers and with members of their families with whom they don't live. Question about safety, because lockdowns meant that children and their parents and their siblings and other relatives were stuck in the same house, in the same physical unit for days and weeks and months, and that's for some wasn't a healthy environment. And now in recent months, I think there is an ongoing awareness to the fact that we have COVID orphanages, where many children have lost their primary caregiver, or if we speak about either parents or grandparents or any other adult that used to take care of these children. I've heard alarming numbers about a number of orphanage children in Indonesia. Last week, a paper was published suggesting that in the US, there are roughly 1 in 500 children in the US are COVID orphanages. So what do we have, back to Fitriya's question, we have awareness. And the framework that we have is the convention, which is still, it still seems relevant into the current situation, but we need to think creatively how to address the new realities of these children's life in a child-friendly manner when we try to provide them with solutions. And COVID orphanages, let's take one step backwards. Being in orphanages is not a new phenomena for children. And we saw the 1924 declaration just beforehand. It partly of the motivation of adopting the 1924 motivation was the high number of children who were left orphanages following the First World War. Again, focusing mainly on Europe, but not only. But that was one of the motivations that led to the creation of this framework to aid children who lost the person or persons that were supposed to take care of them. And it's still very much prevailing in the convention today. We have a good half a dozen articles that speaks about the ways in which we should care for children who lost their primary caregiver, with respect to who should care for them in the future, members of other members of their family or their community or their cultural group, and what sorts of obligations it imposes on states, based on the assumptions that it's better for children to be cared for by their parents, and if they are not available, unfortunately, then again, other members of their families, as long as they can maintain their culture and their religion. And if push comes to shove, the states will have to step in and providing some temporary or long-term solutions for them in the form of foster care, adoption, or if that's unavailable, in the process of children's home in orphanages. So the infrastructure and the perception is there. The question is how you utilize it in this new phenomena and the large scale of COVID orphanages on the one hand, and the economic downside that COVID created for states' budgets, which means that they don't have, sometimes don't have sufficient resources to create these programs that those children will require.
There's another question.
So Rita asks about the child's age with respect to participation. We'll speak about that in a few seconds when we speak about Article 12. So if you want to hold that question, Rita, and then another, so both questions about participation and how we balance participation and age and protection, making sure that participation does not harm children in any way. So we'll speak about that in a second. Any further questions at this stage? Nope. Okay, so let's continue. Article 12, the right to non-discrimination. I mentioned that beforehand in my comments to group number 2. A common article in human rights treaties requiring, in this case, not to discriminate between children and adults, or between the cohort of children based on any of these 11 or 12 characteristics, ethnicity, religious, race, and so on and so forth, suggesting that this is, where are we? This is an open-ended list. By and large, it means that states are under the obligation not to differentiate between children, irrespectively of the group or groups that they belong to or that their parents belong to. If we speak about education, for example, so education, the same educational opportunities and the same quality of education should be available for girls and boys, should be available to citizens and non-citizens alike. And any policies that differentiate between children on those bases and provide inferior education to one of those groups, for example, for girls, suggesting that the age of compulsory education for girls is lower comparing to boys, is a violation of Article 2. That's a common principle and a key principle in human rights and human rights law. It's not unique for children. I'm happy to take questions about it, but I want to move on to the more complicated articles that requires a bit more of unpacking. So I've mentioned Article 6 before as one of the innovation of the convention and one of the unique rights that the convention provides for children. Article 6.1 starts with the common right to life that everyone has, and the convention mentioned that again. You can find the right to life in every other human rights treaty, and it's to some extent it's straightforward. It's the key right. Without the right to life, the protection of all other rights is meaningless. If the state can be in the business of depriving someone from their life, then there is no really point of talking about obligations to protect any of the other rights that we have under the convention. In the context of children, the UN Committee on the Rights of the Child have suggested that Article 6.1, the right to life, doesn't only require a hands-off approach, a negative approach where states should not intentionally or accidentally lead to children being deprived of their life, but also states should take active measures in ensuring that children can keep their life and take active measures to tackle risk factors, for example, car accidents and road accidents, where children in many countries are overrepresented in the numbers of casualties of those who are being casualties of traffic accidents and other events as well. And then it links us, and traffic accidents are only one example. Obviously, it outlaws capital punishment for children, practices of child infantilizations or sex selection, where the legislation enables to abort female status or ignore the practice where female babies are being killed by their parents as expression of cultural preferences to have boys rather than girls. So states should tackle these practices not only because they discriminate between kids, but also because they lead to kids being deprived from their life. A trickier element or a more complicated element is Article 6.2, which speaks about the right to survival and development of children. Survival and development are inherently linked to the right to life, which is a more negative one, but they require some more active measures. So if the right to life is about 0 or 1, either you live or die, the right to survival requires states to take more active measures to ensure children physically survive their growth. Again, the convention was adopted at the 80s when infant mortality rate and under 5 mortality rate were high, and reducing these mortality rates were on the agenda of the international community. So one way to tackle it is to create the right to physical survival that imposes positive obligations on state to make sure that children survive mainly the first few years of their life, where their physical survival is mostly at risk due to issues of nutrition, immunization, access to clean water and other forms of sanitation. But also, as you can see, this definition, it's one definition of the right to survival, one that was provided by the World Health Organization during the drafting process of the convention. We also speak about female literacy, suggesting that without children not being provided with the opportunity to gain basic literacy skills, they won't be able to survive their life. They won't be able to communicate with the authorities. They won't be able to be independent. They will be dependent on others. And basic literacy is the key for survival, so one can make a living and to navigate their way around the world. And again, we as adults, we don't have a similar right recognized in other international human rights treaty. And the other element of Article 6.2 is the right to development of children enshrined in Article 6, but also in addition to Article 6, we see 5 other articles that address 8 different aspects of child development, mental development, physical development, social development, moral development, spiritual development in the context of parental responsibility in Article 18, the rights of disabled children in Article 23, the right to education, and so on. And as you briefly saw beforehand, this is just a reminder, the need to protect child development was situated or was mentioned in paragraph 1 of the first declaration that spoke about the right of the child, suggesting that the aspiration to protect child development is front and center in international child rights law from day one. And we saw that it's manifested also in the convention in Article 6 and in those 5 other articles that mention 8 different aspects of development. And Article 6 is the umbrella right, which speaks about child development in broad terms without defining what child development is. And this is a review of the 5 articles that I've mentioned. Protecting the right to development as part of this life survival continuum requires states to take active measure, to take a holistic approach towards children's life, to understand child development in broad terms, which exceeds and this understanding doesn't come from the law. Though you guys in this training have come from different professional backgrounds, and I'm sure that in your line of work you have very particular understandings of what child development is. Your understanding can come from pedagogy or psychology, from pediatrician or pediatric, all of these disciplines that work and interact with children define childhood, the different understanding of what child development is. And the big challenge is to to bring those different bring this different understanding of child development into the equation, and then creating laws and policies that utilize them in a child rights friendly manner. Question about parental rights to choose a child's religion and belief, and I think speaking about the right to development, this is a very good and important question. Under the convention, parents have the duty to raise their children, and they have, which includes the duty to educate their children in the way that corresponds with parents' belief. So obviously, religious education and religious indoctrination is part of parental prerogative. So under the convention, parents don't have a right to do anything. The focus is on children and on duties that parents have towards their children. So it requires a different mindset when we look at those who are responsible for children, and a different mindset of how we treat or refer or understand the relationship between parents and their children. We no longer, under the convention and under a child right perspective, we don't speak about parents' rights. We speak about parental autonomy and parental duties. And under these duties, yes, parents have the right to indoctrinate their children. It's their prerogative. It's their duty. And states have the duty to respect that autonomy. If we can bring back Article 18 again, you can see that it's stipulated there clearly. Here we are. So Article 18 is one of the 2 articles that regulates child-parent relationship, and we see that parents have the duty here to raise their children and to upbringing them and to support their development. It includes spiritual development. It includes religious indoctrination. One caveat is that it needs to be done in a way that upholds the convention values by and large. So then we are getting into this gray zone of what should we do, how should we treat from a child right perspective to patterns of upbringing or content of religious upbringing that might contradict some of the convention's article. Two that comes to mind: non-discrimination and the differentiation between girls and boys in that space that some religions can justify. And Article 19 that speaks about the need to abolish harmful traditional practices. And the UN Committee on the Rights of the Child, in its concluding observations about Indonesia, spend a lot of time talking about the need to abolish FGM as part of the enshrining child rights in society. And here we have a clear clash between faith and child rights. We can spend a lot of time talking about that later on if you would like, but it's a known clash, if you would like, between views that see the value of FGM and child rights approach and the convention, which explicitly prohibit FGM on the child rights ground. Any questions, or further questions or comment at this stage? No? Okay, so let's continue. So we said about Article 6 that provide this wide protection for child development. One of the main challenges in implementation is to understand or to decide which understanding of child development we are going to use from different disciplines, because the convention is a legal document at the end of the day, but law as a discipline doesn't have any understanding of what child development is. We don't teach child development in law schools. That's beyond our professional vocabulary. It requires interacting and learning from others who work with children in different capacities. Again, I mentioned pediatricians or psychologists or social workers or educators that have a better disciplinary understanding of what child development is. And then we use this knowledge and bring it back into the legal terrain in developing a more nuanced understanding of what the right to development might mean, and how it can be supported and facilitated with respect to different groups of children. Using the example of the Group 2 project, when we speak about protecting children and protecting children, for example, who suffered from past traumas and today are dealing with PTSD, with post-traumatic stress disorder. So their development situation might be very different to those children who weren't subject to these traumas, and their developmental trajectory and the ways that their healthy development needs to be supported is different, and therefore they're accommodating and caring for the right to development will require taking note of their situation and tailoring programs and that takes those under advisement and support their unique needs. And this is where the different competing views of childhood comes into play. By and large, we can think about childhood as a concept in two ways, and the convention tries to dance in between and to accommodate these two competing perceptions. On the one hand, we can look at children as futures. The child is a future adult, and we say that we compare children to adults in terms of their capacities and their capabilities and their maturity. And childhood, in that sense, is seen as a journey. The child, if you would like, that's a famous phrase. The child's only remedy is to grow up. Children should do one thing, and is staying safe and developing into competent adults. And the need to care and the duty to care for their development is an example of a reflection of this journey. If childhood is a journey, then we should be making sure that there is a duty, legal duty, to support this journey. Another way to look at childhood is to give some more value and importance to children's life at the present, looking at children as human beings at the moment, and realizing or acknowledging the importance of the time of childhood in and of itself, in the span of the human life, rather than just looking at its value as the future self that the child has. And then the challenge is, what do we do with the right to development when we look at the present? Development inherently looks at the future, but development also has importance in the present time in different ways. The current developmental status of a child affect their developmental trajectory, and I've given an example to that effect a second ago. But also it means that children in the present should have a say in the ways in which we define and care for their development. And this is a reflection of how the convention as a holistic documents come into play, and how we link Article 6 and Article 12 together. Understanding children's developmental status at the moment and their developmental needs in the future, and how we create and facilitate their healthy process of growth, requires active involvement of children. Besta, you had your hand up.
Yes, I have a question.
Yes.
May I? Okay. I want to ask about how the judges or law officer in Australia ensure the principle of best interest of the child in the legal process, as we all know that the legal process are not really friendly, even dangerous for the children. And because of in Indonesia, there are still like the law officer mostly put the children in the jail just because of a petty crime. And then my second question, like several months ago, I heard about independent children's lawyer in Australia. Maybe could you explain about more about that? Like, what institution that provide the independent children's lawyer, should the parents pay the fee, and other etc. Can you explain more? Thank you.
Yes, thank you. Two questions that probably will take us to 2:30 Sydney time. Question number one, how judicial officers protect the rights of children in Australia? They're not doing a good job at all. The minimum age of criminal responsibility here is 10, which is low. It's way too low than what it should be. The international best practice is 14. That's a recommendation of the UN Committee on the Rights of the Child, which means that children at the age of 10 are subject to the criminal justice system. They can be incarcerated, they became convicted and then incarcerated, and there is massive overrepresentation of indigenous children in the system. There were public inquiries in recent years as to the treatment of incarcerated children in the Northern Territory. In other places where horrific stories of abuse and torture came into light. So the system fails all across the board: the social worker, the police, the justice system, and then the incarceration system. One tiny beacon of light is the independent child's lawyer that you've mentioned. So in some areas of the law, in family law and in criminal law to some extent, children have the opportunity to have to be represented separately in court by a lawyer. We have a system called legal aid, where if the child or the child's family can't afford a lawyer, they will be provided with this free legal service. There is a huge issue of access. I mean, what does it mean if you can't afford it? Legal fees are extortionate, and if your family income is just about a very minimal threshold, you lose this entitlement, so you won't get free legal representation. But it doesn't mean that you can afford one on the private market. It will be just, it's unaffordable for many children, and therefore in many disputes where in principle children can have legal representation, it doesn't happen because them or their parents don't have the resources to pay it on their own pocket on the one hand, and they are not entitled to the free service that the states and territories provide on the other. There were huge cuts to this service in recent years, so now even less children get a separate representation, and it results in poor situation where their rights are being deprived. They might end up being subject to harsher sentences or convicted, while comparing to a situation that they could have been if they would have had a proper legal representation even before trial, at the stage where crimes are being investigated, or when arguing using the, your question that what they're being charged of is a petty crime, and it should not be subject to criminal proceeding to begin with, let alone a trial and then a conviction. So by and large, the situation is far from being ideal, and there is Australia is a developed nation, or we'd like to see it this way. It's a wealthy nation, but when it comes to the protection on the rights of children, it's miles behind any good practices, and miles behind its obligations under the convention. Thank you for that. Let's continue with a few more minutes. I will have to end at 2:30 sharp, unfortunately. I need to dash out and pick up my son from school, and then we'll come back. But I can't, I need to leave at 2:30 sharp. So let's continue with Article 12 of the Convention, which we mentioned will protect the right of children to participate in decisions concerning their life. The text is there with you. As you can see, there is no, it's a comprehensive one. With respect to any decision, big or small, it doesn't differentiate based on the merit of the decision. A child should get an opportunity to participate. What Article 12 doesn't do, it doesn't give children the right to make a decision. And that's a common mistake with respect to Article 12. Whether we like it or not, it's not about the right to make autonomous decision. It's about the right to participate in decisions, and eventually it leaves the power to make decisions about children to adults. And the duty or duties that adults have under this article is to listen to children and to, at the end of the day, give the child views due weight in accordance with the child's age and maturity. So it's, at the end of the day, it's up to an adult to decide, to give a child the opportunity to express their views, but it's up to the adult to decide what to do with those views. And under Article 12, the adult has the ultimate freedom to reject the child's views altogether and to ignore them, assuming we take a literal interpretation of this article. And there are other articles of the Convention that supports this process, that provides children the right to information and to freedom of speech. One cannot express their views if they don't have any sufficient information. Like when we as adults are required to make a decision in our line of work, we need to do that something goes on. We need to have the information, the necessary information in the background, so we can make an informed, we don't make a decision, so we can inform our opinion, which an opinion that won't come out of the blue. There are different ways when children can participate, in which settings, in the classroom, in this medical decision-making about their own bodies. They can have like youth parliaments and elections that mimic the political participation process that we as adults enjoy from. And as I said, the Convention doesn't limit the domains where children participation is expected, and it doesn't limit children's age. What it does speak about children maturity, and then it requires an adult to decide that there is a child here of any age that needs to be participate. Adults needs to be reminded that participation can take different shapes and form, that communication can take different shapes and form. And for some children, due to their age or maybe due to their disability, verbal communication or written communication is not a good option, or is not an option at all. Pre-verbal children are entitled for the rights to participation, but they can't speak their mind. They just can't. And the challenge and the duty is for adults to create the infrastructure and the process that enables children, to participate in the ways that is relevant for their capabilities and to their life. In the scholarship, there are different ways in which a participation was thought of, and one of the best practices today is based on the Lundy model of participation. And I will end my presentation with this slide before I have to step out for 45 minutes. It speaks about four principles. And those of you who got the chance to look at the webinar that we did with Laura Lundy got to hear more about this model from her. And if you didn't get a chance, the link was circulated, so please So please do. She speaks about 4 items that will facilitate a meaningful participation process, and happy to will continue to say a few more words about that after the break. It speaks about space, voice, influence, and audience. Essentially, a child needs to have a willing adult at the other side of the conversation that is willing to listen to them and to give genuine weight to their views. When we have to have a space, a safe space for children, an inclusive space for children where they can express their views, their voice should be front and center of the process. They should be able to have an opportunity to inform their opinion and a range of options as to what's going to happen. If a decision is going to be made, then you need to be aware as to what the parameter of the decisions are. Let's talk about participation in a court process, in a custody hearing, post-separation. Children need to know that there are options, that they can spend more time with their father or with their mother, and what the living arrangement might look like, so they will know what's on stake here. And the same logic applies for every decision that children might be involved with. They need to know what's on stake. An audience is a key element. We need to ensure that children's views, the one that they are communicated, are met by the relevant authorities and by the willing authorities and by willing adults. They need to speak to the relevant person who will make the decision at the end of the day, and that person needs to listen to them, and they need to influence. The participation process should be genuine. It shouldn't be tokenistic, and by all means, children's views can be rejected, but they need to be rejected on their merits and not because, for example, they don't align with what we as adults think is the right or appropriate solution. And if at the end of the day, the child views are not getting a high weight or any weight at all in the final decision, they should be provided with an explanation and feedback as to why their views has been rejected. And if we are linking this to the fourth element, the fourth general principle of the convention, we see how the flow from Article 12 to Article 3 is into the best interest principle, which we mentioned earlier today. At the beginning of our session, when we spoke about group number 2 presentation, the best interest principle is a key principle of international child rights law. It suggests, the convention suggests that in no election concerning children, the best interest should be a primary consideration. And one cannot determine, an adult cannot and should not determine what is in the child's best interest without listening to children. That's a manifestation of how the four guiding principles work together. The best interest principle predates the convention. I'm sure it's also part of Indonesian family law, but it can be interpreted and applied in a very paternalistic way, where adults, sometimes men, tell children, tell women, tell families that they know what is best for them. And one attempt to shy away from these paternalistic views of best interest and from subjective views of best interest is to let children participate in the process of deciding what is in their best interest. And the committee says in General Comment 14 that one cannot perform a best interest analysis without listening to children. The best interest principle is enshrined in the convention in addition to Article 3, mainly, as you can see in this slide, in the context of the child and the family, emphasizing time and again that parental decision or state decision about families should center around children's best interest, rejecting other views about the family and its functions. And this is, here we are. In general comment number 14 that I've just mentioned, the committee said that Article 3 represents essentially a threefold concept. The best interest principle is a substantive right of the child. It's also a fundamental interpretive legal principle and a rule of procedure. One cannot adopt a decision about the child without assessing the impact of this decision on children's best interest. And when a range of options are available for the decision maker, there is a need to assess the effect on the best interest that each of these options will have, and then choose the one that serves children's best interest the most, and that will fulfill the legal obligation to protect the best interest of children. There are attempts in legislation sometimes to codify it, to suggest what the decision maker should take into account when looking into the best interest. And you guys know more how the local legislation looks like. Usually you can find it in the family law context, where again, in the context of separation, one needs to decide about the child age and maturity and the relationship with parents and parental capacity. But also there are other elements of the equation that often comes to play, the child age and cultural and religious practices as to child rearing. Let's open it for questions before we say maybe a few words about the utility of general comments and how general comments number 25 with respect to juvenile justice needs can help you guys in your line of work. There is a question on the chat. Child education, children with disabilities are the most vulnerable group in the COVID pandemic. What is required for inclusive education during the pandemic? It's a tricky question. States are lagging behind their obligations for children with disability in good days, let alone during the pandemic. So school closure and the digital gap and lack of access to stable and reliable internet connection or to electricity or to mobile devices or to computers create a huge issue for children with disabilities for their learning. States, by and large, did very poorly in facilitating access to education for children with disabilities during the pandemic. The amount of resources and attention that inclusive education requires in good days was 10 times more during the pandemic. Children with hearing deficiencies or other physical barriers from access to education usually, by and large, didn't get good solutions from states parties. Local solution, we have some practices of good local solutions that were provided for children, but they were ad hoc. From the point of view of the convention, we can look at Article 28 and 29 and 23 that speaks about the right to education, the aims of education, the right to an inclusive education of children with disabilities, and the right of children with disabilities by and large. And also we can broaden our horizon and look about the right of inclusive education that this Convention on the Rights of People with Disability speaks about. And you'll hear more about it from Rosemary next week. And when we combine these two mechanisms together and the sort of obligation that they create for children, and if you look at the Convention on the Rights of the Child back to our home territory more broadly, and look, for example, on Article 4, that speaks about the sorts of resources that states needs to put into realizing the rights of children, and some rights are costly. When it comes to the right of children, the right to education of children with disabilities, or the right to health, for that example, it requires a lot of public spending into making these rights a reality. And states, as Article 4 stipulates, and as the general comment on budgets and children's rights stipulates even further, are under the obligation to make these rights realized on a progressive on a progression, and to invest as much as they can out of their available resource. So states under the convention cannot get away by saying this is time of austerity, we just can't afford it. They should show how much they have out of their available resources, and how much out of their available resources, realizing that this resources change over time, and the time of pandemic resources were made available for other measures. How much has been invested in realizing child rights? How much has been invested in realizing the rights of the more vulnerable children, as part of ensuring that states are fulfilling their obligations under the convention, including the obligations into the most marginalized and vulnerable group of children. So similar to what we said before the break about what sorts of solutions or new mechanisms are available for children at the time of COVID, The same logic applies here. The mechanisms of the infrastructure that the convention created are in place, and they were still valid during time of COVID. The challenge was with implementation, but the sorts of obligations that states have with respect to children hasn't changed. If at all, it became even more present and more urgent to fulfill them with respect to children, the more vulnerable groups of children, where to some extent maybe on non-COVID times, we're doing okay. And the challenge is for advocacy groups and those who work in this space is to use the infrastructure, but to adapt their advocacy efforts into changing times. But the core principles are there, and they haven't changed. I hope that addressed the question. Children on the move. The question about refugee children and discrimination against children, if there are any best practices, there are better practices. I won't say best practices. Even with countries that pride themselves on non-discriminating between children. We can think about European examples or the Scandinavian example, where the welfare state is praised for their social investment and where they have lots of nice welfare rules in place. They are still discriminate heavily against refugee children based on their status. So they are either incarcerated or being deprived from their liberty in other ways and forms. They are being discriminated with respect to access to education and to healthcare services and other social goods. And it boils down essentially to racism and to social sentiments against refugees. You can see the political sentiment in Europe these days and the backlash, for example, that some countries had after 2015 when European experienced higher numbers of refugees coming from Syria and other conflict zones. So it's a universal problem in that extent. And it's a problem of the ways in which societies and legal systems sees children or refugees' families, and the willingness to ignore this key principle of human rights law of non-discrimination. The convention, which enshrines the right to non-discrimination in Article 2, is not new nor unique. It didn't invent something. We have the right to non-discrimination is part of the Universal Declaration of Human Rights, all other human rights treaties. We have the Refugee Convention from '51. So again, the infrastructure and the logic are there. The case is about implementation, about the political will to implement, and about the pressure or the need to uphold legal principles of non-discrimination. So we can see pockets of better practices. I won't say that we can identify any best practice where refugee children are not being discriminated, full stop. I'm not aware to any such case, but nonetheless, this is the requirement. And upholding the obligations under the convention and the duties that states have with respect to children under the convention requires them not to discriminate between children based on children's civil status. Refugee and citizens, or stateless children, or children without proper documentation, or whatever phrase you would like to use to characterize children's civil status. It boils down, and those titles are a vehicle that states use as justifications for different treatment for different children. But going back to the convention and the instrument that all countries that sign up to, the instrument requires them not to discriminate between children. And again, it's up to each country's accountability measures, either legal or other accountability measures, to try to enforce that and to ensure that children are receiving equal treatment. I hope that answered. To Zico's question, it's a bit of a frustrating answer. It doesn't give you much tools as to what can be done on the ground. But to suggest that it's about upholding duty barriers to account, because the duty from international law perspective is there.
Yes, thank you, Mr. Peleg. Yeah, I just want to share a little bit because the refugee advocates in Indonesia sees that the children on the move issue as, you know, used strategically to use advocates other rights in refugee. For example, we in 2014 and 2015 conduct a, you know, campaign and immigration detention for children, which along the way develop into, you know, we want to release all the refugees out of detention. So I think using the children issue is much more comfortable and much more, you know, acceptable by the governments, because, you know, children who doesn't like children, that way of thinking. So it helps to you know, goal another objective in refugee issue in Indonesia. Thank you, sir.
Thank you. That's good. Didn't know that. Thank you for sharing with us. Question from Harry about how the juvenile justice in Australia protect the legal rights of persons with intellectual disabilities where they have to carry dogs. Again, I'm not a big fan of the local juvenile justice system, and I can't claim that they do any good job. I'm not too familiar with the nitty-gritty of the legislation in this space, and it varies from state to state. So by and large, criminal law is a state matter. Australia is a federation. So most criminal law matters are dealt on a state-to-state basis, including each state sets its own minimum age of legal responsibility, which is commonly 10 in Australia. But also there is a layer of federal law that deals with some criminal law matters. I'm not aware to any good practice that account to these two categories, but what I can say is that the punitive measure toward criminal law by and large, and the ridiculously low minimum age of criminal responsibility, which is 10, suggests that there is no sufficient account to children's chronological age or their developmental age, certainly not if they have any intellectual disabilities or other neurodeficiencies, with the caveat that it can affect their culpability. So they might be in principle subject to the legal proceedings, but on ad hoc basis, they might be deemed to be lack of the sufficient culpability to be held account for their action. But that can be a lengthy ad hoc process that will get children off the hook rather than they have a systematic and more robust approach in this space. Ririn, you have your hand up.
Ririn?
Yes, please.
Yep. Thank you, Niall. I have a question. The right of education is for everyone, including children with disability. In Australia, in every state, they are already implementing education with inclusion, and what the challenging? Because not in every school in Indonesia there are inclusion, because a lot of budget, and also the most important, the perspective about disability and inclusion quite far away to go.
You're right. It's a crucial issue, and it's crucial for children with disability, and various forms of disabilities present different challenges. It's a state matter. By and large, education issues are state-based matters, and there are various policies and legislation in place with respect to the entitlement of children with disabilities for education. The general approach is in favor of inclusive education. There was a move from segregated schools and nurseries and so on into more inclusion, and there are some resources thrown into it with some more additional support in schools that some children deserve. But it depends on the level of resources that are being put into it. And then the sorts of support that children need. Some need some support in intermediation communication. Some require physical support due to the nature of their disability. And that affects a lot. Where there is a question whether these services are available, because it requires different support people with different set of skills. Between physical support is one thing, translation, sign language translation requires a different skill set. But spoke about infrastructure. In most states, the infrastructure exists. There's a question whether the services can be delivered in terms of resources like budget, and if there is a support person available, and how much support is provided. So for some children, the school day lasts for 6 hours, but support will be only available for 3 hours, for example, which leaves children in a limbo for the rest of the school day or half of the school days. Depends how the resources are allocated. There is a huge urban-rural divide where more services are available in urban places, and in some more remote communities, the services are not as widespread, which leaves children and their families in a position where they can't attend school or cannot attend school meaningfully. I'm cautious with the time and lots of questions are coming. There is a question from Besna about the family court in Australia, how they ensure the livelihood and child support in divorce cases. I would assume that you talk about monetary livelihood, whether how can I ensure that sufficient funding goes toward children. There is a separate set of legislation that's called Child Support Assessment Act. It's a federal matter where parents are obliged to financially support their children while they are still in a relationship with the other parents and when the relationship break up. So if post-separation, let's take an example, the child spent most of his time with his mom and he sees his father every second weekend or more often, both parents are under the obligation to provide financial support for the upbringing of their child, including the non-residential parent. And if parents can't achieve an agreement how to allocate the sum of money between them, then the court will make an order saying to the father, you need to pay X amount of money every fortnight or every week in order to support your child. If parents don't have the sufficient resources, there is some form of social welfare assistance which is available for parents. It's on minimal level. It's a test-based. It's a income-based test that determines your eligibility. But in that, I was trashing the criminal justice system. In that context, there is some form of support from the state that provides a minimal level of financial support for families, while pre-divorce as well. So you can apply for some financial support from the state before divorce. We know from statistics that once parents separate, women's financial stability is challenged. Many mothers headed households fall into poverty post-separation, and even if there are court orders in place, I won't say many, some men don't oblige with these orders. They use it as a way to leverage pressure on the mothers to see their children more, and so on and so forth. This process can be abused, but there is some safety net provided by the federal state to families and women in that case. Let's take one last question, and I will leave it to Patrick and Anna to conclude the session for you at 3:40 Sydney time. Lots of issues that we haven't covered that I promise you that we will cover, and that Patrick promised you that we will cover. The slides, speak with them, and as I said, I'm happy to take questions over email if you have at some point. But if you have one last question or comment now, I'll be happy to take it. Okay.
There are no hands up at the moment, so people are probably still taking in all that information.
Sorry that I had to rush and that I need to
sorry, Risky just put his hand up.
Yeah, go for it. Yeah, Risky, please.
Yeah.
Baik, terima kasih atas kesempatannya. Saya ingin
Sorry, Noam, if you go down to the bottom, you can listen to the English translation.
Yeah, I'll try to do that. Yeah, okay.
Okay, start again.
Baik, saya akan ulang pertanyaannya. Terkait negara bagian di Australia, kondisinya berbeda dengan di Indonesia. Kita hanya satu negara dengan memiliki banyak daerah dengan latar belakang yang berbeda-beda. Dan kemampuan finansial dari masing-masing pemerintah, dukungannya juga tidak sama. Apalagi di Indonesia banyak pengangguran yang secara finansial dikatakan miskin jika dibandingkan dengan negara Australia yang kaya. Apalagi kondisi disabilitas di Indonesia ini sangat rentan menjadi miskin, dan saya ingin tahu bagaimana peran pemerintah di negara bagian di sana mendukung kebutuhan bagi orang-orang disabilitas. Itu saja pertanyaan dari saya. Terima kasih. Thank you.
I can speak about the role with respect to children with disabilities. Again, the CRPD, which we're going to hear more about next week, speaking about the role, the roles that states have with respect to everyone, children and adults alike. Not least because the needs are different. And the needs of children with disabilities are different compared to the needs of people of adults with disabilities, if you would like. And we've mentioned some of them today already. And usually speaking, and it requires an individual assessment due to the people have different form of disabilities that presents different challenges and different opportunities. But from the point of view of the convention, we have Article 23, and those that we've mentioned today, and the main one be the right to development. So the role is to support the healthy development and the optimal development of a child, including a child with disability, if it goes to ensuring full access to inclusive education, and then that the education environment is adequate to the child's need and capabilities, with the support that it requires, whether it's a sign language translation or other forms of facilitating physical access to education, that education material will be provided in braille writing form, for example, and so on and so forth. Rehabilitation, physical rehabilitation and exercise that some are needed, healthcare services that are adequate and adaptable. It's all sound to an extent very naive. And in terms, it's an optimal structure that the convention provides, and its subject, its implementation, I think, and the challenge with this implementing this broad obligations that states are under boils down to three things: it's awareness, it's willingness, and it's budget. And sometimes the lack of budget or the suggestion that there is insufficient budget is a camouflage or an excuse to lack of willingness to work more towards inclusion and towards support people and children with disabilities. And this is where, and I will end my answer with that, more advocacy is needed and more listening to children is needed, because children with disabilities usually know more about their life and what they need, what sorts of support they need in order to support their own life and their own childhood and their own development. And their solutions are not only creative, more relevant to their life, but more often much cheaper and simpler comparing to what adults think that they should need. And that's the constant message that I'm trying to convey today, that policies with respect to the support to children with disabilities needs to be developed and implemented with the participation of children and those who work with them. And it presents a huge challenge. communication issues and so on and so forth are a challenge, but they have to be accommodated, or otherwise, from a child right perspective, the process is problematic. And thank you for that, guys. It was great to meet you today. I hope we all learned something. Again, I said, if you have any further question, always happy to have a chat. Drop me an email. And I wish you best of luck with the rest of the course, with your line of work, and all the best. Thank you very much.